that you were running late. What we're going to do now is I'm going to instruct you a little bit about the law that you will follow in this case, and then we'll go right into opening statements. So, ladies and gentlemen of the jury, before we hear the opening statements of counsel and begin to take evidence, I will read to you some preliminary instructions to follow in listening to and considering the evidence which you will hear in this case. I will also give you some further instructions after you've heard all the evidence that covers additional law which you are to follow. It is my duty to instruct you in the law, and it is your duty to follow the law as I state it to you both now and at the conclusion of the trial. And at the conclusion of the trial, I'm going to give you a notebook with all the written jury instructions for you to take back in the jury room so you can consult that during your deliberations. It is your exclusive duty to decide all questions of facts submitted to you and apply the law which I give you to the facts as you find them. You must decide the facts from the evidence received in this trial and from not from any other source. You must determine the effect and the value of the evidence. You must not be influencing your decision by mere sentiment, conjecture, sympathy, passion, or prejudice towards any party, witness, or attorney in this case, or public opinion or public feeling. If I repeat any principle, instruction, or state it in varying ways, no emphasis is intended by me and none should be inferred by you. All of the court's instructions, whether given before, during, or after the taking of testimony, are of equal importance. The attorneys for the parties, of course, will take very active roles in the trial. This may include making opening statements to you, questioning witnesses, making objections, and then finally arguing the case to you at the conclusion of the evidence. Please remember that attorneys are not witnesses. Since it is your duty to decide the case based only on the evidence which you see or hear in this case, you must not consider as evidence any statement of any attorney made during the course of the trial because they are not witnesses and they are not sworn to testify under a penalty of perjury. Now, like most things, there are a couple of exceptions, and there are two exceptions to this rule. First, if the attorneys agree to any fact, then I will advise you of such a situation. That's called a stipulation. In other words, if all the parties agree that a certain fact is true, they don't waste your time by bringing a number of witnesses to establish that fact is true. If the attorneys enter into a stipulation, I will let you know, and then you must accept that stipulation as being true. The second exception is one I have never seen occur in my courtroom to date, and that is if one of the attorneys takes an oath to tell the truth and sits up here on this chair, on this witness stand, and then testifies as a sworn witness in the case. As I said, I've never seen that happen. I don't expect it to happen in this case either, but I just want to make sure you understand that what attorneys say in our opening statements and closing arguments is not evidence. Now, after the opening statements and beginning tomorrow, the people will offer their evidence. Evidence usually consists of testimony from witnesses as well as any exhibits that are admitted into evidence. After the people present their evidence, the defense may also present evidence, but they are not required to do so. Because he is presumed innocent, the defendant does not have to prove that he is not guilty. It is the people's burden alone to prove that the defendant is guilty. After you have heard all the evidence and before the attorneys give their final arguments, I will instruct you in the law that applies to the case. After you've heard the arguments and instructions, you will then go to the jury room to begin your deliberations. You must decide what the facts are in this case. You must use only the evidence that is presented in the courtroom. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else that I tell you to consider as evidence. We have rules of evidence that have been developed over the years which will guide us in the conduct of the trial. Generally, you may not fully understand why we have those rules, but I assure you there are good reasons for them, even if those reasons are not apparent to you. Now, during the course of the trial, an attorney may make an objection to the introduction of certain testimony. He or she, in effect, is saying that in his or her opinion, the offered testimony is not permitted by the rules of evidence. Now, whenever there's an objection that's made, I will either sustain the objection or overrule the objection. When I sustain an objection, the witness will not be permitted to answer the question. You must not guess why I have sustained the objection, and you may not speculate as to what the answer might have been. When I overrule an objection and the evidence is permitted, That does not express any opinion as to how you should treat such evidence. All that ruling says is that you have a right to hear such evidence. But you as jurors may completely reject such evidence. You may give it very little weight, or you may give it a great deal of weight. That is your responsibility as jurors, because you are the judges of the facts. If any answer is given to a question and the court then grants a motion to strike out the answer, you are then to completely disregard the answer, and you must not consider it for any purpose. Just treat it as though you never heard it. You should keep in mind that a question in and of itself is not evidence and may be considered by you only as it helps you to understand the answer. Do not assume to be true any insinuation suggested by a question that is asked of a witness. You must disregard anything you see or hear when a court is not in session, even if it is done or said by one of the parties or one of the witnesses. No statement, ruling, remark, or comment which I may make during the course of the trial is intended to indicate any opinion I may have as to how the jury should decide the case or to influence the jury in any way in its determination of the facts. At times, I may ask questions of the witnesses. If I do so, it's for the purpose of only bringing out matters that I feel should be clarified and not in any way to indicate the weight I feel the jury should give the testimony of any witnesses. Now, as I've told you before, very good trial lawyers in this case. I'm just going to let them try their case. However, if I'm confused about an answer or about a location or who they're talking about, I might jump in and just clarify it, but it'll be a rare occasion when I do that. Now, as I stated earlier, the defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove each element of a crime and each element of every allegation beyond a reasonable doubt. Whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that is received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he's entitled to an acquittal, and you must find him not guilty. Now, any fact in this case may be proved by either direct or circumstantial evidence, or by a combination of both. Now, direct evidence can prove a fact by itself. Circumstantial evidence sometimes is referred to as indirect evidence. And I'm going to read you the definition of circumstantial evidence now. Keep in mind it was written by a bunch of lawyers and judges, so see if you can follow this. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may conclude the truth of the fact in question. So I hope that clears it up for you. Let me give you an example. Let's assume that the only question in this case is whether or not the defendant was swimming in a backyard swimming pool. And a witness comes in here under oath and takes the stand and testifies, I saw the defendant in the swimming pool. Well, that's direct evidence of the ultimate fact which you are asked to decide. Now, let's say a witness comes in and says, I didn't see the defendant in the swimming pool, but I walked into the backyard. The water was all choppy as if somebody had just been swimming. There was nobody else in the backyard, and there were wet footprints leading up to the defendant, who was standing there soaking wet in a bathing suit, dripping water all over the place. Now, those facts all constitute circumstantial evidence that the defendant was in the pool, but it does not directly prove that he was in the pool. So with that said, let me reread the definition of circumstantial evidence for you. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may conclude the truth of the fact in question. Now, both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental states and acts necessary to a conviction, and neither is necessarily more reliable than the other. You must decide whether a fact and issue has been proved based on all the evidence. Now, as jurors, you have the exclusive duty to decide the credibility of the witnesses who will testify in this case, which means that it is you who must decide whether to believe or disbelieve a particular witness and how much weight, if any, to give to the testimony of each of the witnesses. The testimony of each witness must be judged by the same standard. You must set aside any bias or prejudice you may have, including any based on the witness's gender, race, religion, or national origin. In deciding whether testimony is true and accurate, use your common sense and your experience. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and then decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony, including but not limited to the following factors: the extent of the opportunity or the ability of the witness to see or hear or otherwise perceive the things about which the witness has testified, the ability of the witness to remember or describe what happened, the witness's behavior while testifying here in court, whether the witness understood the questions and then answered them directly, the existence or non-existence of a bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in the outcome of the case, the attitude or demeanor of the witness about the case or about testifying, whether the witness made a statement in the past that is consistent or inconsistent with his or her testimony, and finally, the reasonableness of the witness's testimony when considered in light of all the other evidence in the case. Now, do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the very same event, yet see it or hear it differently. If you do not believe that a witness's testimony that he or she no longer believes or remembers something, that testimony is inconsistent with the witness's earlier statement on that same subject as to whether or not they remembered making a prior statement. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but then told the truth about others, you may simply accept the part that you think is true and then ignore the rest. Both the people and the defendant are entitled to the individual opinion of each juror. That means that each of you, for yourself, must determine the factual issues to be resolved in this case. Some words or phrases that may be used during a trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in the instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in the instructions are to be applied using our ordinary everyday meanings. Please keep an open mind throughout the trial. Don't make up your mind about the verdict or any issue until after you've discussed the case with the other jurors during deliberations. Now, do not take anything I say or do during the course of the trial as an indication of what I think about the facts, the witnesses, or what you think your verdict should be. When we come back tomorrow, you will be given notebooks and some pens that will be on your chairs when you come in, along with a summary of the charges that will help you with the dates and the counts and Jane Doe's 1 through 5 and which Jane Doe pertains to each count. You're not going to get the notebooks today because we're just going to do opening statements today. As I told you, what the attorneys say is not evidence. So when you come in tomorrow, the notebooks will be on your seat. Please do not remove the notebooks from the courtroom. You cannot take them outside on a break, and you cannot take them home. You will be able, however, to take your jury notes into the jury room when you deliberate. You may use your notes during deliberations only to remind yourself of what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. If there is a disagreement during the trial or during deliberations about what actually happened at trial, you may ask that the court reporter read back the relevant parts of the testimony to assist you. Please do not let your note-taking distract you from your ongoing responsibility to evaluate the witnesses and the evidence. Now, just a word of caution, if you do act for readback, the court reporter has to go through the testimony and remove any objections and remove any stricken testimony, so it may take her time to prepare that. There's also a misconception that transcripts are prepared every day from the testimony, and that's not the case. The transcripts in a case like this may take months to prepare. So Sometimes I'll get a note from the jurors, can you send back all the transcripts? The answer is going to be no, because the transcripts do not exist yet. Now, I also expect that police reports will be mentioned throughout the trial, and a lot of witnesses may refer to police reports to refresh their memories to what they said at an earlier occasion. It is proper for the attorneys and the witnesses to refer to police reports during the trial. However, the written police reports themselves are not evidence for a number of legal and evidentiary reasons, and therefore you will not be receiving copies of the police reports back in the jury room during your deliberations. If it does appear to you that some reference in a police report is important to your understanding of the facts, you can just jot it down in your notes. You must not allow anything that happens outside of the courtroom to affect your decisions during the trial. Again, I'm going to remind you, do not read, listen to, or watch any news reports or commentary about this case from any source, if any. And I'm really going to ask that you be diligent in this case, because there's going to be a lot of media coverage on this case. Don't read anything in the paper. This may or may not be the lead story on the 5 o'clock news, so be very vigilant when you turn on the news. If you see anything about this case, shut it off, leave the room, and don't watch it and don't read anything. You'll also may have noticed when you go outside the courthouse and look to your right, there are a bunch of media tents and media trucks that are parked out there. And that's where those people I told you about last week, the mind readers, are out there, and they're going to tell everybody what you're thinking and how you're taking any evidence. I'm going to order you stay away from that part of the parking lot and don't go over there and listen to anything they're saying. What's important in this case is that you make your decision on what you hear in the courtroom and not what you hear from any media source outside the scope of the trial. Do not do any research or investigate on your own at all or as a group. Do not use a dictionary or the internet. Do not Google anything about this case. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you happen to pass by one of the scenes, do not stop and investigate. If you have a cell phone, I know all of you do, or other electronic device, please keep it turned off while you're in the courtroom and during jury deliberations. An electronic device includes any electronic storage device as well. As I told you last week, if somebody needs to get a hold of you during the course of the trial, they can call the courtroom and we will deliver any emergency message to you right away. You can certainly check your phones at the recess and at lunch as well. During the course of the trial, it may be necessary for the court and counsel to meet outside the presence of the jury, either back in my chambers or out in the hallway, or sometimes I'll ask you to leave the courtroom and we'll have a discussion outside your presence while you're outside the courtroom. You should not speculate on these proceedings because they concern legal issues upon which the court must rule before the trial may proceed. Now, during the trial, you may meet the attorneys or other witnesses in the hallways or in the elevators. Again, please not think they're being unfriendly when they do not speak to you. All these attorneys are very, very nice people, but if you go up and try to talk to them, they are going to be a little bit rude and tell you that they can't talk to you. It's by order of the court. You are directed to have no conversation of any kind with any party, attorney, witness in this case during the course of the trial. Likewise, the attorneys, parties, and witnesses are also directed not to speak to any juror during the course of the trial. Do not listen to anyone who tries to talk to you about the case or about any of the people or subjects involved in it. Again, if someone asks you about the case or about which case you were sitting on as a juror, just tell them that you cannot discuss the case. If that person keeps talking to you about the case, you must end the conversation immediately. When the trial has ended and you have been released as jurors, you may discuss the case with anyone you want, but that's at the end of the trial, and I will let you know when that happens. Under California law, I'm required to advise you and instruct you that you must wait at least 90 days before negotiating or agreeing to accept any payment for information about this case. If you receive any information about this case from any source outside of the trial, even if it's unintentional, do not share that information with any other juror. If you do receive such information, or if any person attempts to improperly influence you or any member of the jury, you must report such attempt immediately to the court. Just write a note out to Manny, and Manny will deliver it to me immediately. Counsel, I can instruct you to have your witnesses not converse anywhere where the jurors may overhear them. And for the jurors, I'm going to ask you always wear your juror badge, especially in a hallway here, because that way potential witnesses will know that you're a juror on the case and they won't discuss the case near you. Also, you need to wear your juror badge when you go out to lunch, because there may be jurors who might be, witnesses who might be having lunch nearby, and if they see that you're a juror on the case, they can move to another table. That way they can identify you and make sure that they don't discuss anything that you shouldn't be hearing. Do not let bias, sympathy, or prejudice or public opinion influence your decision in any way. And finally, you must reach your verdict without any consideration whatsoever of punishment. I went through the trial schedule with you last week, and I gave you the trial schedule that you could take home with you. Again, you need to be available to serve until June 21st. On a normal day, we will go till 12 o'clock and take a 15-minute break in between that time. We'll start up again at 1:30 and go to 4:30 with a 15-minute break in between. The breaks are not only for your benefit, they're also for the benefit of the court reporter, who gets quite a workout transcribing or reporting everything that happens here. All right? So with that said, it is now time for the attorneys to give their opening statements if they so desire. They will outline what they expect the evidence will show in this trial. Please remember, what the attorneys say is not evidence. That's not to say what they're about to tell you is not helpful to your understanding of the facts. So that said, are the people ready to give their opening? Yeah. All right, go ahead whenever you're ready.